Last month, Masaka High Court granted bail to MPs Allan, Ssewanyana and Ssegirinya on charges of murder, attempted murder and terrorism. Unfortunately, these two were rearrested. The move was protested by a number of people, but according to lawyer Simon Peter Chinowe, who we spoke to on this matter, said police has the authority to rearrest someone on new charges. However, city lawyer Male Mabirizi revealed that the move was unconstitutional, prompting him to run to the Constitutional Court. Today, Justice Chiberion Barishaki, one of the justices of the Constitutional Court, heard this case and said as scheduled. Mabirizi says they have agreed on a number of facts that they will rely on in the hearing of this case.
The first one being whether the respondent's answer to the petition is properly before the court. The Constitutional Court rules require that upon being served the petition, the Attorney General had to respond within 7 days from service. Now, we served the Attorney General on 30th September 2021, but they responded on 8th. That is outside the 7 days.
Male Mabirizi says it's unconstitutional to arrest a person and then charge him or her on the same counts.
And then the right to liberty under Article 23. If I've been granted bail, and then after being granted bail, you arrest me, you charge me with another just one other person. Yet in other cases, people are just remanded. I mean, the charge sheet is just amended so that new cases, all new cases are added together. So that's the third issue. And then the fourth is remedies.
And it was wrong for the judge to also read the same offences to them.
By the DPP and remanding by Masaka Chief Magistrate of Ssewanyana and Ssegirinya on a new file arising from Masaka Bijambia is in contravention of the Constitution. That's the gist of the file, I mean of the petition. And then we have listed the several articles of the Constitution which are contravened, mainly Article 28(9) of the Constitution, which prohibits double jeopardy. But also there is Article 44C of the same Constitution, which talks about the right to fair hearing.
He now wants this court to declare all the proceedings that led to their being charged again as unconstitutional and then release the MPs unconditionally.
The Constitutional Court rules. So I was reminding him that as he's saying that the petition shall be heard in the next convenience session, I was telling him that actually that's not the law. The law says shall be heard within 7 days after the after the scheduling conference, because the framers of the Constitution and the rules did not envisage that what will happen will be a session. They envisage the situation that the moment a petition is conferenced, it will be heard, and then that constitutional question is determined once and for all. So that's it for today.
Mabirizi now is waiting for court to set a date to hear his queries, and by law, it must be heard by 5 justices of the Constitutional Court.